So first coming up is Renata, who will be our moderator for this session. Renata leads legal and privacy at Payphone, and as you guys know, a lot of data travels through Payphone, and as you kind of heard from her in the audience, she has pretty interesting opinions on how New Jersey should change their legislation. So hopefully she'll be able to share some of those thoughts deeper in the panel. And she also has a background in another industry, in the gaming and also records industry as a litigator. So hopefully she can bring the perspectives from those industries as well. And then in the center is Howard. And Howard is the CISO at Medient, which is owned by FireEye. And he's been kind of a pioneer in some of these data perspectives. He wrote one of the first papers on computer viruses. He's been at the NSA and he's been at Bell Labs. So he has a deep perspective to share. And Seth, you've already seen him once today, but for those of you who joined a little later, he is from Interpublic Group in the privacy part of the organization. And this session is going to be on data governance. So if you think about the last session from compliance as responding to things reactively, this is about how to be proactive. And if you think about Pankaj's one question about what is the importance of the accounts, how do you look at the accounts? This is the type of stuff you need to think about for data governance. So I'll pass it off to Renata.
I guess I'll stand a little bit. Yeah, like each of you stand when you speak to. My name is Renata Lowen Brown, Rena for short. I've been an attorney for, this month is officially going to be 30 years. So I have a broad range of a background. Incidentally, I guess our previous speaker said he was a member of a group. Actually, Def Jam Records and Island Records used to be here, actually, at Worldwide Plaza. They no longer are there, down on Broadway now. I was going to add that then. Nothing having to do with privacy, but an interesting fact. And I am now in-house counsel, the vice president of legal, and I oversee privacy and products for a company in its growth phase, actually, that does mobile authentication and identification. Basically, we're a back-end provider that if you use your cell phone or if you're on even a computer and you're going to access your online account with your retail company, your bank, anybody, we're usually the back-end processor that helps companies identify who you are. And whether the mobile phone you say is yours really is, and whether it's with you. And so we think quite a bit about privacy and impending legislation and how to, and how, right from a technological perspective, how to really be compliant with what's there. So we're in the center of quite a bit of that, I think. So it's very challenging for everyone here, I'm sure. So I actually wanted to begin with a couple of questions for the rest of our panelists, just really on our topic generally, right? So really, what do you really perceive governance is, data governance and privacy governance, and what has your experiences been in terms of, at least the way I see it, the necessary buy-ins that probably are needed from, right, the products people, if you happen to be a company, right, creating products, and the lawyers and the compliance people and the security and privacy people. How does that interplay within your organizations, and where do you feel there is gaps, or if you were the grand poobah of creating an organization, how would you structure it?
Okay, so I'm Howard Israel. I work for Medient. It's a division of FireEye, and we specialize in information security, cybersecurity, and we do a lot of work in breach responses for customers that call us. We've averaged something like 2 calls a day from customers. Is that better?
Yep.
Even still, 2 calls a day from customers to help them out with breach responses. Honestly, they're calling us before they call the police or FBI for help. So, the question around governance. So, cybersecurity, information security, data security, way back when, used to be kind of standalone. It started out in the technology group, then it kind of moved into legal sometimes. Sometimes it was on its own. It gets shuffled around a lot because it doesn't have a real good home. These days, the catchphrase is GRC, Governance, Risk, and Compliance, which is a catch-all to deal with compliance issues as well as governance. So from the board all the way on down, so that there is some backing, some backbone, and some bite around getting things done from a security point of view. Because security does tend to get short-lived as well as privacy often. And so there's this issue around like how do we get some backing on this? How do we get the executive backing? And how does this get reported to the board? So now it's sitting at the GRC, which is typically under legal. That's where most organizations tend to put it these days. Not all. It's not been standardized. There's no law that says it has to. But a lot of places over the last, say, about 8 to 10 years have moved in that direction.
Yeah, thank you.
Seth Lewak, I'm not going to bore you with an introduction again, but I think in terms of data governance, so I think it depends upon your organization. If you're a larger organization, you may have a chief data officer. And I've seen companies now are putting privacy or privacy compliance or whatever under chief data officer, meaning that they're trying to integrate those two. Obviously, thinking about data management from a privacy perspective, which is an interesting concept because privacy always, it varies from company to company on where it should sit. But going back to data management, it's interesting because I think a lot of not newer companies, so older companies, are dealing with legacy systems. So what happens is that they never really thought about data management until recently and realized, hey, we have this vast amount of data that we could either be using or we need to know where our information is. And now they're trying to get a handle on it, either because of regulatory issues or just to understand their data. So I think that, if you have these legacy systems, it makes it much more harder. If you didn't develop in, the new cloud, the public cloud, it makes things much trickier to know where your data is, where your information is, and importantly for us, from a privacy perspective, where your personal information is, so that we can properly either access it, deal with access requests such as CCPA, GDPR, and how we're actually using it and storing it.
Great. I think, can anybody hear me? I don't hear myself. Okay, so I think I want to jump in, and I know on the outline we have, I think I want to do number 2 first, and I'm going to leave both of you to speak about it. I think, so if your organization is thinking about putting, I don't know whether you have an existing, say, privacy program or whether you are thinking about implementing one, but that's usually a starting point, and a starting point where I want to begin here when it comes to critical issues that either one of you have seen during data inventorying and data mapping and that process, and really what you can recommend would be best practices given the experiences you've had. And perhaps both of you can also further sort of elaborate on what that is and how important it is for privacy compliance.
What to start?
Yeah.
Okay. So data mapping, data inventory, usually referred to together. Data inventory is just understanding what data you're collecting, processing, using, sharing, etc. But when you're doing these data inventories, you could be doing it either automatically. There's a few solutions out there that are on the market that are pretty expensive. But if you're doing it manually, you're just categorizing what information you're collecting more broadly, who and what you're sharing the data with, how you're protecting it, what's your purpose of processing, for instance, with GDPR.
Well, yeah. And actually even at more basic, why is it that an organization should be doing that?
Sure.
And updating its policies now? I don't know.
So specific to CCPA, for instance, you need to know where your information is if you're going to deal with access requests. So if you get a request day 1 and Gen 1, you're going to need to know where your personal information is in order to provide to the customer. So you don't want to be left, not knowing where your data is and blowing past your SLA or your 45 days.
And for GDPR.
And for GDPR.
They require actually too that you have to do data mapping. And even if there wasn't anything out there, it's a good best practice because you need to, right? Most organizations will have different classifications of data, and there's a reason. Because how you treat highly sensitive data, right, that might be very different than something that's purely confidential. And so knowing where they all reside is probably the first step in coming up with a more compliant program than what you're already doing. So,
and that's why it goes hand in hand with information security as well, because if you're classifying it, you know how to protect it. So if you bucket those classifications in one of those, 4 or so classifications usually, so confidential, highly confidential, public, internal, however, every company's different. Somebody like Howard would know how to go in and protect that personal information or information in general.
So if you are running a compliance program, how would you go about updating, right? Like what practices would you recommend you put into place or that you might already have to be able to reassess whether you really have identified all of the information that's within your organization? And again, given all of the different types of events that could occur, for instance, maybe your company has acquired a new company, right, or acquired a piece of it. So that's my question to both of you.
All right, so privacy, in my experience, has been chiefly driven by executive, primarily the legal organization, right? They're the ones that are the big proponents of it. They're the ones that request compliance to it and tell their organization to implement.
Oh, do we have a question? I guess
No.
Okay.
So they're the drivers. They say, here's what the law is, here's what it says, here's where we think it applies to our organization. So they tell that to the CTO or the CIO, the security guy, and then we have to say, okay, let's research this a little bit, let's figure out what this means to us and what are the implications. And that becomes a challenge. So that becomes a challenge to map and to gain an understanding about what the meaning is and its application and its interpretation with respect to your organization. And you have to drill that down into actual technical requirements in terms of, do we need to make any changes to our systems in terms of the collection, the storage, the management, its life cycle, its destruction, everything about that to comply with these new rules, these new legal rules. We have to turn them into technical requirements, and then we have to figure out how we're going to implement those. So that's kind of the process at a rough level. Now, in my experience, I have not seen a whole lot of organizations jumping up and down and say, gosh, we need privacy, it's an important thing. I think it's still very much in the beginning stages, and I think the law like the CCPA is going to be a big driver in terms of raising that awareness and compliance to that sort of thing, much like the data breach laws were, like 15 years ago when they started coming out, starting from California, working their way across the country. And that's going to be a challenge too, because from my point of view, being in information security, cybersecurity, my challenge is satisfaction and compliance and proving compliance to customers, to regulators, to third parties, to the executives, to the board, up and down the chain, right? So that's a big problem because like the data breach laws, we had one state, then we had another, then a few more, and before we know it, we had a patchwork of all these very, very similar laws on the same topic, but the details were different, and some of them actually contradicted each other, believe it or not. And that makes for a big compliance headache. And if the same thing happens with CCPA, which looks like it's going to, because just the other day I read, and one of the links that was shared with me with the panel members, that there's 4 or 5 states that have draft privacy laws similar to CCPA.
New York.
It died on me. Oh, it's bad. New York, New Jersey, and a few others. And if it's hard enough to comply with one state law that's new, it's hard to interpret, you have to figure out, it's a new landscape. And now we have 4, 5, 10, 20, 30, 40, 8, 50, plus the territories, plus international, on the same subject, but all slightly different or maybe vastly different. That's a compliance nightmare from my point of view, in terms of how do I prove, right?
And I was going to mention, I've had the experience, which I consider a very good one, of working for an organization in the past where they actually were better than the law. They made a decision that they were going to designate certain types of information. At the time, it was actually local government information that they didn't feel was necessarily right, subject to state or regulatory, and they were going to treat that in a certain way because they wanted to be better. They wanted to avoid reputational damage. And so I know I pose that actually to my CEO all the time, right? Do we want to be better? We might have other reasons. And so that's something to consider as well. That, right, a group such as yours might be charged with having to handle, right? It's more often than not, that's not the case, but you would be responsible for that because you would now have to consider certain types of data, right, in one of these categories and treat it, right, as the organization might now deem it. And it might actually involve having to do brand new inventories. So I'm wondering also, what have each of your experiences been in terms of collecting that data or getting information from different business units generally? And again, if you had the choice of how you would do it in a perfect world, what else would you recommend, if you could, if there's anything to recommend?
So I think trying to automate it is extremely difficult. And some bigger companies are trying to do that and automate the process of knowing where, figuring out where their personal information is. And I think it just brings it, maybe in the long term, it can bring about, ease of use. And if you use some sort of algorithm or machine learning or whatever the
Right, they should automate as in using a third-party service who can go in and literally, right, with a spider web almost, go in and detect that data and pull it for you so you can know about it. I know that there's things out there like that. We don't use that. But I know that, right, I've had folks come to me who have wanted to use it. And that's what you're talking about.
Yeah, exactly right. And some organizations are building it internally as well. But I think that's kind of far off, and from what I've seen, hasn't been very good. So I think at the end of the day, it's going to come down to a manual process. So it's getting your stakeholders involved, and whether if you're a lawyer in privacy, you're probably not going to know where the information is, right? You're going to have to get your stakeholders involved. You're going to have a lot of organizations are coining privacy champions, having people in the business that, from HR, technology, and the business organizations to kind of come together as a group and determine what information they're collecting and using, and et cetera, et cetera. So really filling out that inventory. So, you really got to have stakeholder buy-in, and the only way I've seen to have stakeholder buy-in is from the top, unfortunately. So if you have executive sponsorship and whatnot, I think it just died on me. Should be good to go. Yeah, I think it just died.
Or should I, is that working?
Sometimes it does, sometimes it doesn't.
Better now?
Renata, the mic is a little fell apart.
I have no idea.
So that is the microphone in your
Oh,
right,
this
your
is the
left
mic. All right,
hand.
well, I'm going to give you the mic. Okay. Let's take this one. Okay. Here, hold this too. We're gonna.
Oh, you can hold it. Thanks.
Oh,
So, what I would do is, I don't believe that there's a technical solution to be able to scan your systems to identify what is going to be within scope of this responsibility. Thank you. So, it's going to be a manual process. The focus will be here's how we'll work in real life. The focus will be on your bigger systems, the systems with the most data, the systems that are known to have sensitive data on it. That will be the first phase, is to figure that stuff out. And it's going to be a challenge. I mean, this is not going to be easy. And when I read these laws, so my focus is, all right, how do I implement this? How do I get this done? How do I get compliant with it? In the first challenge, I mean, literally, in the first paragraph, I say, oh, this applies to California consumers. Okay, so how do I tell which customer records are California consumers? Should I assume that the address is, if it's in California, that it is? I mean, that's not 100%, because the person could technically be a resident of California but have a different address. They could be overseas and be a California resident. I don't know. They could be inside California but a UK resident, right? So that's not really perfect. So that's a challenge. There's so many challenges in this technically to comply. Honestly, it's going to be round after round of effort and refinement to try to get better at it, to do better at collecting and identifying on data intake, what is within scope, what is not in scope, and try to identify it at that point in time, whether it's sensitive or, you know, how sensitive, whether it falls under, it doesn't fall under, things like that. But I'll tell you, in a typical system, and I know you're not technology, we have mostly lawyers here, right? That's what I saw earlier, right? And how many, just out of curiosity, how many chief privacy officers are there? Not too many, okay. Well, you know, do you work in the chief privacy, in a chief privacy office of organizations, enterprises? We have one person, okay. So, when the data gets put into it, for example, an app or a website, you know, that may be stored actually inside the app or the website. It may be put into a log file and then transferred to a backend database, where, by the way, it's also going to be logged in a transaction log, and it may be logged as other transformations or processing occurs on that data. So the data may, quote unquote, be in one place, theoretically, but in reality, the same piece of data may be in half a dozen, if not a dozen or more different places over the course of its life. They may be stored in temporary files. They may be stored in log files at the end of the day processing. They will be stored in backups of those files, and of course the main source of data as well. And it may be replicated in multiple locations, you know, for redundancy's sakes. So, you know, this technically is a non-trivial problem for a single application, let alone a slew of applications, let alone conglomerates, large, you know, Fortune 50, 100 companies that have 100 or more subsidiaries, that have dozens and dozens of applications that they run in each one of those subsidiaries, some of them hundreds, if not thousands. This is a big, complex problem. There's no doubt about it. Like, my head blows up when I think about this sort of thing. And by the way, I thought GDPR was, in some respect, a little bit worse. When I read the stuff about trans-border flow, I'm like, no one writes applications around that stuff. You know, if it stays within the UK initially, that was kind of like dumb luck, right? Or in the EU initially, that was just pure chance. But, you know, now we've got to go and check all those applications to see which ones, and then we have to go and change them and fix them. I mean, this is insane, right? This is crazy. I realize that's the law, but extremely difficult and non-trivial to deal with and to assure proper compliance, in my point of view.
So you brought up a nice point that I'm going to dig deeper into for either one of you. So at least my next set of questions was going to be, hey, what do you think are the most challenging aspects of CCPA, right? When you've got to go back to legal in particular and say, hey, I can or I can't do that. And so one we already heard, which everyone is scratching their heads about, is the right to the deletion of the data. Can you really do it? And at least I know we're getting, you know, requests for our compliance folks for our contracts, right? Requests now, you know, can you ensure that you can delete data, right? PII, personal information, if in fact there's a request. And so that was an interesting perspective to hear you speak on it. But besides that, what, for either one of you, can you focus on one or two things that you feel are a tremendous challenge that right, an attorney in privacy or legal should know about to help either guide you or dig down and figures, you know, another way of handling, right? Those type of things.
You want to go? I'll hold it up. That's fine.
So I think the biggest issue that we are facing, and I think a lot of in the advertising space, is the sale, the opt-out the opt-out of the sale of personal information. Specifically, it says within the CCPA, you might have seen, you know, that it's an exchange for personal information for value or other valuable consideration. So what does that valuable consideration mean within the programmatic or targeted advertising space is a huge, it's, you know, the space is complicated to begin with, and then you add on this, where is the sale actually taking place within the kind of many different players in the space, is very difficult to discern. So, you know, it can depend upon the context, and knowing without further guidance from the AG, and I doubt it's going to come, it's very difficult to understand where the sale is taking place. For instance, And even so, no company, no client or company, an advertiser wants to display on their website, I do not sell my personal information.
Well, you have to put something up. You have no choice.
Well, it depends upon what you consider a sale. So, if the advertiser is not considering that what they're doing a sale, they're not going to put it up, or they're going to kind of argue that way, one way or the other, which makes it difficult.
Provided you don't give the ability for somebody to enter their personal information on your website, which might not really be your end consumer or your end customer, right? So it's two separate things.
So,
Good.
so even if it's your customer and they're visiting your website, right? They're collecting through cookies, browsing history, et cetera, you're sharing that information potentially with some sort of advertising ecosystem, right? That sharing of information is not necessarily needed for you to provide target advertisement. So that's where the trick is. And this is debatable too, so it's a complete mess right now. Yeah.
So, as you're probably well aware, everything is subject to interpretation, right? And we do a lot of that when it comes to interpreting these types of laws. At some point, from an implementation point of view, you have to make the interpretation, you have to make a decision about how we're going to interpret some phrase or some requirement, such as the right to know, the right to delete, expunge or whatever, and deal with that and implement something that you interpret to meet the needs within the context of the system that you're dealing with, the data that you have around those customers and the system itself. And by the way, there's another issue, of course, which I didn't bring up, but is conflict between other laws, which I know there's an exemption of, for example, data retention laws and things like that. So those two require interpretation, and you have to figure out, is this going to be an exempt item with respect to the law or not? For what reason? What's your justification? You better have one and you better document it so in 3 years when someone calls you on that, you know what the train of thought and thinking was to declare something exempt or not so, or within scope. So that implementation-wise, these are challenges. These are serious challenges from a technical point of view, which is trying to show that compliance. I don't know what else to say. I know we're close to timeout, right? Do we have time for Q&A?
Yeah, we have time for about 2 questions.
2 questions. Moderator.
I'm the moderator. Does anybody have any questions?
I'd love to ask a question.
Okay, David.
So as somebody who's coming to this, kind of green, trying to sort of project into the role of someone who would be, working with a technology officer like yourself, Howard, how would you characterize the challenges with trying to do things like identify classifications of information, with classifications that match up what the regulations are contemplating. So identifying and tagging, adding metadata, partitioning and segmenting databases. How would you describe those challenges? And is there, in the second part of that question, is there an expectation that those challenges will be easier now that we understand what's expected, and that something like the privacy by design concept, when you're upgrading systems, creating new databases, designing new customer portals, that those things would be like infinitely easier at the next technology upgrade cycle, or is that not the case? That it's always expected to be really difficult?
Yeah, and I just wanted to add, it's interesting that you asked that question and listening to you talk, because to me, I'm just going back to this theme I began in the beginning. You could have folks, right, doing security and technology who are more than capable of interpreting as best they can, right, different legislation and different pieces of it. But more important is, right, for that team to know when they should be getting in a buy-in for the interpretation they think is correct, because often it's really a strategic legal decision. And I find in my experience sometimes there's not as much of a good information exchange and mutual buy-ins on issues such as that, particularly security, for what it's worth. But, yeah.
Yes, so that communication line is important to have that open and to get constant feedback as decisions get firmed up and decided upon. I think that's critical. I don't. This is not a one-way conversation. So for greenfield, for new implementations, I mean, vastly easier to consider these requirements on a new system. On an upgrade, well, that now becomes a challenge. Now you have your regular purpose of the upgrade, which might be performance, increased capacity, a whole host of functionality, whatever. And now you have to consider these other requirements in here. Most people, I'm sure, are probably going to opt for a very simplified approach. Like try to keep things simple so we can manage it, right? The more complex things are, the harder it is to manage. I mean, technology, we have learned that lesson very clearly. So one might say, for a particular application or system or database, we're going to classify everything at one classification level. Just take everything in and simplify it. Okay? So everything that goes in is going to get that classification. When it gets exported, that classification of that information that knowledge of that has to go to the next system or next file or whatever, or server and be protected suitably with that respect. That's kind of the easiest way out, because you can go crazy on this stuff, trying to do it at a granular level, by record, by column, by query, and you can drive yourself just literally nuts. Because every new query, every new modification database, you have to go back and you have to ask that question all over again. Well, is this going to be classified at this level or that level, right? So believe me, people want simple. Everyone wants simple. Life is complex enough without having to make it more complex. Go ahead.
So to that point, do you see a move towards just classifying everything at the highest level and making it easier? Or is there, I know it's more expensive, obviously, to secure things at a higher level.
It may be less expensive just to do that,
less, yeah.
because you treat everything the same.
Right.
Maybe you decide you can provide these sets of controls that maybe include encryption in transit or storage, whatever you decide, right? Special audit functions or things like that. It may be simply just do it for everything. Simpler, easier, and cheaper in the long run, and just better off.
Right, because so much data now is personal information under the law, so it requires enhanced protection. So it's almost kind of like when is that line getting drawn between everything and then everything?
I can tell you, I can give you a sort of a downside to that, right? And it goes to probably what all of you have done when it comes to the contracts. So certain types of data, right? The other side might require that you're going to, right, respond to a security incident or data breach, depending on how the data is classified, and so that can become very burdensome in the event of a security incident or data breach.
Sure.
So that's a negative to that easy solution.
There's pros and cons.
Yeah.
Pros and cons.
Like then there's the ease of use, right? You restrict the data, you restrict the applications. The more controls you put in place, the more frustrated the business gets at the end of the day. And you can only do so much before. And depending on it all depends upon the type of business you're in. So if you're in financial, obviously more sensitive data, healthcare, all that. But that. At the end of the day, I think you're just going to get pushback, right, from the business.
That was two. I counted two. 2.5, 2 3/4 questions.
All right. Well, I'd like a round of applause for our panelists and moderator.